Hello there, YouTube blogosphere. It's John Igarashi. I'm a California attorney with over a decade of experience. I'm coming to you to speak with you about evictions during this time of COVID-19. So I have to give my usual disclaimer. This video is for informational purposes only. It is not intended to be legal advice. If you have a legal situation, you should definitely consult with an attorney in your jurisdiction regarding your facts. So I'll mention preliminarily that in general, commercial tenancies aren't going to get a lot of protection. In general, commercial tenants are just going to have to pay their rent on time. And even as to residential tenancies, the government really isn't providing that much protection. And even where there is some protection, it's not blanket protection and often requires some degree of action on the tenant's part. One thing that's creating a natural barrier to the filing of evictions is that the courts are largely closed. So that by itself is going to delay a lot of evictions. So first, let's talk about the federal protection that has come about as a result of the CARES Act. If the rented property is covered by a federally backed loan, that is a Freddie Mac loan, a Fannie Mae loan, or a VA home loan, and or the tenancy is a covered tenancy as designed in the Violence Against Women's Act, which includes a whole laundry list of different kind of tenancies, but I will mention that one of them is Section 8 vouchers. Then there is a 120-day moratorium against evictions, late fees, and charges. And that 120-day period goes through and including July 24th, 2020. And actually, the CARES Act protection is fairly strong because it says that if the property is a covered property or if the tenancy is a covered tenancy, then there is protection generally against evictions, charges, and late fees. In fact, a landlord cannot even serve a no-fault notice to vacate the premises until July 24th, 2020. A no-fault notice to vacate is a notice to vacate that is not based upon a failure to pay rent or a violation of the lease. Now, if you have a covered tenancy, both the landlord and the tenant probably know that it is a covered tenancy. As to whether the property is a property covered by a federally backed mortgage, a landlord could pretty easily find out by looking at the Freddie Mac or Fannie Mae websites or calling the VA. However, there's really no way for a tenant to find out whether they live in a property that's covered by a federally backed mortgage. In fact, probably one of the only ways that a tenant could find out would be after the eviction action is already filed. The tenant would file an answer and then use court discovery procedures to request information and documents from the landlord as to whether the property is backed by a federally backed loan. But as a practical matter, less than half of all loans are federally backed loans, so it would be really risky for a tenant to rely on the covered property protections of the CARES Act. So if the tenancy is a covered tenancy, pretty much any eviction is going to be barred by the CARES Act. And if the property is a covered property, then pretty much any eviction is going to be barred by the CARES Act. But because only the landlords are going to know or have the ability to find out whether the property is covered by a federally backed loan, the landlords are pretty much going to have to self-govern on that point. Otherwise, the first place to look for guidance is whether a state, a county, or a municipality has issued some kind of order that prevents tenants from being evicted. So unfortunately, I can't go city by city or county by county because that would just be too voluminous. But I will mention what the state of California has done, and I will mention some things to look for when looking at city and county orders. Landlords and tenants should be looking at the city and county orders because those orders are going to have to be complied with in addition to anything the state has ordered. As to the California governor's statewide order, it really provides relatively little protection. Primarily, it delays the time for a tenant to answer an eviction complaint by 60 days. That time is normally 5 court days. Also, it does not prevent no-fault evictions. Furthermore, the tenant has to have suffered a COVID-related loss of income. In addition, the tenant has to notify the landlord within 7 days of when the rent would have been due, and the tenant has to retain documents that show that the loss of income was related to COVID. So while I can't go city by city or county by county, what I can do is I can post in the description links to resources that reflect the different types of eviction protection that are being afforded by various cities and counties of which I am aware. Also, I'll mention a few things that I think that landlords and tenants should keep in mind when looking at these city and county orders. First, what does the order prevent or delay? Is it the filing of an eviction case? Is it the charging of late fees or something else? Second, does it require the tenant to take some kind of action? Does it require the tenant to give notice within a certain time? Does it require the tenant to provide documentation to the landlord within some particular time? Of course, all of these deadlines should be observed. Third, does it apply to no-fault evictions? Meaning, can a landlord simply issue a 30 or 60-day notice to quit? Well, that's all I have for you today. I hope some of this information was helpful to you. I would appreciate it if you could hit the like button, subscribe to the channel, and maybe even hit the notifications bell so you can be apprised of when new videos come out. Thank you for watching.